Findings of fact. Having considered the evidence presented at trial, the credibility of witnesses, and the legal arguments presented by counsel, the court now makes the following findings of fact pursuant to FRCP 52A. The court relies primarily on the testimony and exhibits cited herein, and although uncited cumulative documents evidence is in the record and considered by the court, also supports the findings. The parties. Plaintiffs. Kristen Perry and Sandra Steer reside together in Alameda County, California, and are raising 4 children. They are lesbians in a committed relationship who seek to marry. On May 21, 2009, Perry and Steer applied for a marriage license from defendant O'Connell, the Alameda County clerk reporter, who denied them a license due to Proposition 8 because they are of the same sex. Paul Katami and Jeffrey Zarillo reside together in Los Angeles County, California. They are gay men in a committed relationship who seek to marry. On May 20, 2009, Katami and Zarillo applied for a marriage license from defendant Logan, the Los Angeles County clerk, who denied them a license due to Proposition 8 because they are of the same sex. Plaintiff intervener. San Francisco is a charter city and county under the California Constitution and the laws of the state of California. California Constitution, Article 11, Section 5A, San Francisco Charter Preamble. San Francisco is responsible for issuing marriage licenses, performing civil marriage ceremonies, and maintaining vital records of marriage. California Family Code, Section 350A, 401A, 400B. Defendants. Arnold Schwarzenegger is the Governor of California. Edmund G. Brown, Jr. is the Attorney General of California. Mark B. Horton is the Director of the California Department of Public Health and the State Registrar of Vital Statistics of the State of California. In his official capacity, Horton is responsible for prescribing and furnishing the forms for marriage license applications, the certificate of registry of marriage, including the license to marriage and the marriage certificate. Lynette Scott is the Deputy Director of Health Information and Strategic Planning for the California Department of Public Health. Scott reports to Horton and is the official responsible for prescribing and furnishing the forms for marriage license application, the certificate of registry of marriage, including the license to marry, and the marriage certificate. Patrick O'Connell is the Alameda County Clerk Registrar and is responsible for maintaining vital records of marriages, issuing marriage licenses, and performing civil marriage ceremonies. Dean C. Logan is the Los Angeles County Registrar Recorder County Clerk and is responsible for maintaining vital records of marriages, issuing marriage licenses, and performing civil marriage ceremonies. Defendant interveners. Proponents. Dennis Hollingsworth, Gail J. Knight, Martin F. Gutierrez, Hak-Shing William Tam, and Mark A. Jansen are the official proponents of Proposition 8 under California law. Proponents comply with a myriad of legal requirements to procure Proposition 8's enactment, such as filing forms, prompting the state to prepare Proposition 8's title and summary, paying the initiative filing fee, drafting legally compliant signature petitions, overseeing the collection of more than 1.2 million signatures, instructing signature collectors on state law guidelines, and obtaining certifications for supervising signature gatherers. Proponents dedicated substantial time, effort, reputation, and personal resources in campaigning for Proposition 8. Tam spent the majority of his hours in 2008 working to pass Proposition 8. Martin Gutierrez described activities to pass and enforce Proposition 8. Miscellaneous declarations by Dennis Hollingsworth, Gail J. Knight, Mark A. Jansen. Proponents established protectmarriage.com, yes on 8, a project of California renewal as a primarily formed ballot measure committee under California law. Declarations of Hollingsworth, Knight, Gutierrez, Tam, and Jansen. The Protect Marriage Executive Committee includes Ron Prentice, Edward Dulce, Mark A. Jansen, and Doug Swarmston. Andrew Pugno acts as general counsel. David Bauer is the treasurer and officer of record for Protect Marriage. Based on the declaration of Ron Prentice and letter from Protect Marriage to Jim Abbott, letter to a business that donated money to a group opposing marriage, 8 demanding a donation of like amount to Protect Marriage, letter signed by Ron Prentice, Protect Marriage Chairman, Andrew Pugno, Protect Marriage General Counsel, Edward Dolce, Executive Director, California Catholic Conference, and Mark Jansen, a Protect Marriage Executive Committee member. Protect Marriage was responsible for all aspects of the campaign to qualify Proposition 8 for the ballot and enact it into law. Based on email from Kenyon Curtin to Family Research Council to Prentice, Curtin attaches a kit to be distributed to Christian voters through churches to help them promote the proposition. Curtin explains to Prentice that Family Research Council found out from Pugno that the Family Research Council needs to take FRC logos off the California version of the videos and just to put protectmarriage.com on everything. Email from Pugno to Tam, other emails from Pugno to Tam, Tam's participation in a debate, Tam's Protect Marriage reimburse individuals around print and television ads. Tam signed a statement of unity with respect to Proposition 8 campaign on behalf of himself, behalf of the Traditional Family Coalition. Email from Tam, I'm still waiting for a proposition for protectmarriagecampaign.com instructions on when we should start the signature collection. Protect Marriage is a broad coalition of individuals, organizations, including the Church of Jesus Christ Latter-day Saints, the LDS Church, and the California Catholic Conference, and a large number of evangelical churches. ProtectMarriage.com, Protect Marriage about page identifies a broad-based coalition. Statement from Frank Schubert and Jeff Flint on passing Proposition 8 politics. We have the support of virtually the entire faith community in California. Segura's statement, churches, because of their hierarchical structure and ability to speak to congregations once a week, have a very strong communications network with churchgoers. A network of 1,700 pastors working with Protect Marriage in support of Proposition 8 is striking because of the sheer breadth of the religious organization and its level of coordination with Prop Marriage. Segura further states an organized effort and formal association of religious groups form the broad-based coalition of Protect Marriage. Segura's statement, the coalition between the Catholic Church and the LDS Church against a minority group, was unprecedented. Email from Prentice to Len Vinson explaining that from the initial efforts in 1998 for the eventual success of Prop 22 in 2000, a coalition of many organizations has existed, including evangelical, Catholic, and Mormon groups, and identifies Catholic and evangelical leaders working to pass Proposition 8. Ron Prentice addressing supporters of Proposition 8. An excerpt from his statement, he explains the importance of contributions from the LDS Church, Catholic bishops, and evangelical ministers through the Protect Marriage campaign. Frank Schubert and Jeff Flint statements, by this time leaders of the Church of Jesus Christ of Latter-day Saints had endorsed Proposition 8 and joined the campaign executive committee. Even though the LDS were the last major denomination to join the campaign, their members were immensely helpful in early fundraising providing much-needed contributions while we were busy organizing Catholic and evangelical fundraising efforts. Whether any evidence supports California's refusal to recognize marriage between two people because of their sex. Marriage in the United States has always been a civil matter. Civil authorities may permit religious leaders to solemnize marriage, but not to determine who may enter or leave a civil marriage. Religious leaders may determine independently whether to recognize a civil marriage or divorce, but that recognition or lack thereof has no effect on the relationship under state law. The basis for that is statement civil law has always been supreme in defining and regulating marriage. Religious practices and ceremonies have no particular bearing on the validity of marriage. Any clerics, ministers, rabbis that were accustomed to performing marriages only do so because the state has given them the authority to do so, and the Family Code, section 400 and 420. A person may not marry unless he or she has a legal capacity to consent to marriage. Marriage is a basic civil right. It expresses the right of a person to have the liberty to be able to consent validly, and the Family Code, sections 300 and 301. California, like every other state, has never required that individuals entering a marriage be willing or able to procreate. California Family Code 300. The case in re marriages, this contention that marriage is limited to opposite-sex couples because only a man and woman can procreate or can produce children biologically related to both is fundamentally flawed. Lawrence v. Texas, Judge Scalia dissenting. If moral disapprobation of homosexual conduct is no legitimate state interest for purpose of prescribing that conduct, what justification could there possibly be for denying the benefits of marriage to homosexual couples exercising the liberty protected by the Constitution? Surely not the encouragement of procreation, since the sterile and the elderly are allowed to marry. There has never been a requirement that a couple produce children, statement by Cott, in order to have a valid marriage. Of course, people beyond procreative age have always been allowed to marry. Procreative ability has never been a qualification for marriage. When California became a state in 1850, marriage was understood to require a husband and a wife. See the California Constitution, Article 11, Section 14, and in re marriage cases. The state has always required the parties to give their free consent to a marriage. Because slaves were considered properties of others at the time, they lacked the legal capacity to consent and were thus unable to marry. After emancipation, former slaves viewed their ability to marry as one of the most important new rights they'd gain. From Cott. Many states, including California, had laws restricting the race of marital partners so that whites and non-whites could not marry each other. Basis, Cott. Many as 41 states and territories, the law placed restrictions on marriages between a white person and a person of color. Again, Cott. Racially restricted marriage laws prevented individuals from having complete choice on whom they married in a way that designated some groups as less worthy than other groups. Defenders of race restrictions argued the laws were naturally based on God's plan, just being put into positive law. The efforts to undo them met extreme alarm among those who thought these laws were correct. People who supported racially restricted marriage laws saw these as very important definitional features of who could and should marry and who could not and should not. Chauncey. Jerry Falwell criticized Brown v. Board of Education because school integration could lead to interracial marriages, which was then sort of the ultimate sign of black and white equality. Nathanson's statement. Defenders of race restrictions in marriage argued that such discrimination was protective of the family. Pace v. Alabama, holding that anti-miscegenation laws did not violate the Constitution because they treated African Americans and whites the same. The Attorney General admits that California banned interracial marriage until the California Supreme Court invalidated the prohibition in Perez v. Sharp in 1948. Proponents admit that California banned certain interracial marriages from early in its history until the California Supreme Court invalidated those restrictions in Perez. Racial restrictions on an individual's choice of marriage partner were deemed unconstitutional under the California Constitution in 1948 and under the United States Constitution in 1967. An individual's exercise of his or her right to marry no longer depends on his or her race, nor on the race of his or her chosen partner. Basis Loving v. Virginia. United States Supreme Court, 1967. Perez v. Sharp, California, 1948. Under coverture, a woman's legal and economic identity was subsumed by her husband's upon marriage. The husband was the legal head of the household. Coverture is no longer part of the legal bargain. The Attorney General admits that the doctrine of coverture, under which women once married lost their independent legal authority and became the property of their husbands, was once viewed as a central component of the civil institution of marriage. Caught under coverture, the wife was covered, in effect, by her husband's legal and economic identity. She lost her independent legal and economic individuality. Caught. Coverture was a marital bargain to which both spouses consented, and it was a reciprocal bargain in which the husband had certain very important obligations that were enforced by the state. His obligation was to support his wife, provide her with the basic material goods of life, and to do so for their dependents. Her part of the bargain was to serve and obey him, to lend to him all of her property, and enable him to take all of her earnings and represent her in court or in any sort of legal or economic transaction. Caught. Coverture was, quote, a highly asymmetrical bargain that to us today appears to enforce inequality, but I do not want to stress it was simply domination and submission. It was a mutual bargain, a reciprocal bargain joined by consent, unquote. Caught. The sexual division of roles of spouses began to shift in the late 19th century and came fully to an end under the law in the 1970s. Currently, the state's assignment of marital roles is gender neutral. Quote, both spouses are obligated to support one another, but they are not obligated to one another with a specific emphasis on one spouse being the provider and the other being the dependent, unquote. Follansbee versus Benzenberg, quote, the legal status of a wife has changed. Her legal personality is no longer merged with that of her husband, unquote. Marriage between a man and a woman was traditionally organized based on presumptions of a division of labor along gender lines. Men were seen as suited for certain types of work and women for others. Women were seen as suited to raise children, and men were seen as suited to provide for the family. Caught. Marriage laws historically have been used to dictate the roles of spouses. Under coverture, a wife's legal and economic identity was merged into that of her husband's. The coverture system was based on assumptions of what she was then considered a natural division of labor between man and woman. Caught. Quote, assumptions were, at the time, that men were suited to be providers, whereas women, the weaker sex, were suited to be dependent, unquote. Letitia Ann Peplow and Adam W. Fingerhut in The Close Relationship of Lesbian and Gay Men, published as an article, quote, traditional heterosexual marriage is organized around two basic principles, a division of labor based on gender and a norm of greater male power and decision-making authority, unquote. Nathanson. Defenders of prejudice or stereotypes against women argued that such discrimination was meant to be protective of the family. Henrik Hertog, in a lecture entitled Marital Exits and Marital Expectations in 19th Century America, quote, even in equity, a wife could not usually sue under her own name, unquote, and, quote, the most important feature of marriage was the public assumption of a relationship of rights and duties, of men acting as husbands and women acting as wives, unquote. In the article, A Reconsideration of Husband's Duty to Support and Wife's Duty to Render Services, quote, marriage deprived the wife of her legal capacity in most matters affecting property, unquote. The development of no-fault divorce laws made it simpler for spouses to end marriages and allowed spouses to define their own roles within a marriage. Cott. No-fault divorce, quote, was an indication of the shift, that spousal roles used to be dictated by the state. Now they are dictated by the couple themselves. There is no requirement that they do X or Y if they are one spouse or the other, unquote. Cott. The move to no-fault divorce underlines the fact that marriage no longer requires specific performance of one marital role or another based on gender. Henrik Hertog, in a lecture entitled Marital Exits and Marital Expectations in 19th Century America, states, in 19th century America, marriage was permanent. Spousal roles were non-negotiable, and divorce, quote, punished the guilty for criminal conduct, unquote, and, quote, provided a form of public punishment for a spouse who had knowingly and criminally violated his or her public vows of marriage, unquote. Stevenson and Wolfers, in the article Marriage and Divorce, Changes and Their Driving Forces, state current divorce rates are consistent with trends that developed before states adopted no-fault divorce. That was written in 2007. In 1971, California amended California Civil Code Section 4101, which had previously set the age of consent to marriage at 21 years for male and 18 years for females, to read, quote, any unmarried person of the age of 18 years or upwards and not otherwise disqualified is capable of consenting to and consummating marriage, unquote. In the 1970s, several same-sex couples sought marriage licenses in California, relying on the amended language in California Civil Code 4101. In response, the legislature in 1977 amended the marriage statute, formerly California Civil Code 4100, to read, quote, marriage is a personal relation arising out of a civil contract between a man and a woman, unquote. That provision became Cal Family Code Section 300. The legislative history of the enactment supports the conclusion that unique roles of a man and a woman in marriage motivated legislators to enact the amendment. In 2008, the California Supreme Court held that certain provisions of the Family Code violated the California Constitution to the extent the statutes reserved the designation of marriage to opposite-sex couples in remarriage cases. The language, quote, between a man and a woman, unquote, was stricken from Section 300, and Section 308.5, Proposition 22, was stricken in its entirety. California has eliminated marital obligations based on the gender of spouse. Regardless of their sex or gender, marital partners share the same obligation to one another and to their dependents. As a result, Proposition 8, California, nevertheless requires that a marriage consist of one man and one woman. Eliminating gender and race restrictions in marriage has not deprived the institution of marriage of its vitality. Proponents admit that eliminating the doctrine of coverture has not deprived marriage of its vitality or importance as a social institution. The Attorney General admits that gender-based reforms in civil marriage law have not deprived marriage of its vitality and importance as a social institution. Cott, quote, "The primacy of the husband as the legal and economic representative of the couple and the protector and provider for his wife was seen as absolutely essential to what marriage was," unquote, in the 19th century. Gender restrictions were slowly removed from marriage, but, quote, "because there was such alarms about it and such resistance to change in what had been seen as quite an essential characteristic of marriage, it took a very, very long time before this trajectory of the removal of the state from prescribing these rigid spousal roles was complete," unquote. The removal of gender inequality in marriage is now complete, quote, "to no apparent damage to the institution," and, in fact, I think to the benefit of the institution, unquote. Proponents admit that eliminating racial restrictions on marriage has not deprived marriage of its vitality or importance as a social institution. The Attorney General admits that race-based reforms in civil marriage law have not deprived marriage of its vitality or importance as a social institution. Cott, when racial restrictions on marriage across color lines were abolished, there was alarm, and many people worried that the institution of marriage would be degraded and devalued. But, quote, "there has been no evidence that the institution of marriage has become less popular because people can marry whomever they want," unquote. Marriage is the state recognition and approval of a couple's choice to live with each other, to remain committed to one another, and to form a household based on their own feelings about one another, and to join in an economic partnership and support one another and any dependents. The state has many purposes in licensing and fostering marriage. Some of the state's purposes benefit the persons married, while some benefit the state. Facilitating governance and public order by organizing individuals into cohesive family units. Cott, quote, "The purpose of the state in licensing and incentivizing marriage is to create stable households in which the adults who reside there and are committed to one another by their own consent will support one another as well as their dependents. Developing a realm of liberty, intimacy, and free decision-making by spouses." Cott, quote, "The realm created by marriage, that private realm, has been repeatedly reiterated as a realm of liberty for intimacy and free decision-making by the parties," unquote. Creating stable households. Cott, "The government's aim is to," quote, "create stable and enduring unions between couples," unquote. Legitimating children. Cott, "Historically, legitimating children was a very important function of marriage, especially among propertied families. Today, legitimation is less important, although unmarried couples, children still have to show that, quote, they deserve these inheritance rights and other benefits of their parents," unquote. Assigning individuals to care for one another and thus limiting the public's liability to care for the vulnerable. Cott, Marriage gives private actors responsibility over descendants. Quote, the institution of marriage has always been at least as much about supporting adults as it has been about supporting minors, unquote. Facilitating property ownership. Marriage is, quote, the foundation of the private realm of property transmission, unquote. States and the federal government channel benefits, rights, and responsibilities through marital status. Marital status affects immigration and citizenship, tax policy, property, inheritance rules, and social benefit programs. Budget. Specific, tangible economic harms flow from being unable to marry, including lack of access to health insurance and other employment benefits, higher income taxes, and taxes on domestic partner benefits. Cot. The government has historically channeled many benefits through marriage. As an example, the Social Security Act, quote, had a very distinct marital advantage for those who were married couples as compared to either single individuals or unmarried couples, unquote. United States Accounting Office report research identified in 2004, quote, a total of 1,138 federal statutory provisions classified in the United States Code in which marital status is a factor in determining or receiving benefits, rights, and privileges, unquote. Marriage creates economic support obligations between consenting adults and for their dependents. The purpose of the state in licensing or incentivizing marriage is to create stable households in which the adults who reside there and are committed to one another by their own consents will support one another as well as their dependents, unquote. Family Code, Section 720. Marriage benefits both spouses by promoting physical and psychological health. Married individuals are less likely to engage in behaviors detrimental to health, like smoking or drinking heavily. Married individuals live longer on average than unmarried individuals. Peplow. A recent large-scale study by the Centers for Disease Control found that married individuals on average fare better on, quote, virtually every measure, unquote, of health compared to non-married individuals. Proponents admit that opposite-sex couples who are married experience on average less anxiety and depression and greater happiness and satisfaction with life than do non-married opposite-sex couples or persons not involved in an intimate relationship. Peplow, quote, the very consistent findings from a large body of research on the impact of marriage on health are that on average married individuals fare better. They are physically healthier, they tend to live longer, they engage in fewer risky behaviors, they look better on measures of psychological well-being, unquote. Egan, quote, married individuals are healthier on average and in particular behave themselves in healthier ways than single individuals, unquote. Charlotte A. Schornberg, in an article, Marital Status and Health, United States, 1999 through 2002, United States Department of Health and Human Services, published in 2004, quote, regardless of population, subgroup, age, sex, race, Hispanic origin, education, income, or nativity, or health indicator, fair or poor health, limitations in activities, low back pain, headaches, serious psychological distress, smoking or leisure time physical inactivity, married couples were generally found to be healthier than adults in other marital status categories, unquote. California Health Interviews Survey, published 2009. Married individuals are less likely to have psychological distress than individuals who are single and never married, divorced, separated, widowed, or living with their partner. Press release from the Agency for Healthcare Research and Quality, entitled "Marriage Encourages Healthy Behavior Among the Elderly, Especially Men." October 26, 1998, Marriage Encourages Healthy Behaviors Among the Elderly. Material benefits, legal protection, social support resulting from marriage can increase wealth and improve psychological well-being for married spouses. Basis: Lupton and Smith, Marriage Assets and Savings. Marriage is correlated with wealth accumulation. Badgett: Marriage confers numerous economic benefits, including greater specialization of labor and economies of scale, reduced transactions costs, health and insurance benefits, stronger statement of commitment, greater validation and social acceptance of the relationship, and more positive workplace outcomes. Some benefits are not quantifiable, but nevertheless are substantial. Proponents admit that societal support is central to the institution of marriage, and that marital relationships are typically entered into in the presence of family members, friends, and civil or religious ceremonies, authorities. Proponents admit that marriage between a man and a woman can be a source of relationship stability and commitment, including by creating barriers and constraints on dissolving the relationship. The long-term nature of marriage allows spouses to specialize their labor and encourages spouses to increase household efficiency by dividing labor to increase productivity. Proponents admit that marriage between a man and a woman encourages spouses to increase household efficiency, including by dividing their labor in ways that increase the family's productivity in providing goods and services for family members. The tangible and intangible benefits of marriage flow to a married couple's children. Lamb, explaining that when a cohabitating couple marries, that marriage can improve the adjustment outcome of the couple's child because of the advantages that accrue to marriage. American Psychiatric Association article support of legal recognition of same-sex civil marriages, written July 2005. Marriage benefits children of that couple. Whether any evidence shows California has an interest in differentiating between same-sex and opposite-sex unions. Same-sex love and intimacy are well documented in human history. The concept of an identity based on object desire, that is, whether an individual desires a relationship with someone of the opposite sex, heterosexual, same-sex, homosexual, or either sex, bisexual, developed in the late 19th century. Chauncey: The categories of heterosexual and homosexual emerged in the late 19th century, although there were people at all times, periods in American history, where primary erotic and emotional attractions were to people of the same sex. Herrick: Heterosexual and homosexual behaviors alike have been common throughout human history. Herrick: In practice, we generally refer to three groups: homosexuals, heterosexuals, and bisexuals. Herrick: Sexual orientation is, at its heart, a relational construct, because it's all about a relationship of some sort between one individual and another, and a relationship that is defined by the sex of the two persons involved. Sexual orientation refers to an enduring pattern of sexual, affectional, or romantic desires for and attractions to men, women, or both sexes. An individual's sexual orientation can be expressed through self-identification, behavior, or attraction. The vast majority of people are consistent in self-identification, behavior, and attraction throughout their adult lives. Basis: Herrick: Sexual orientation is a term that we use to describe an enduring sexual, romantic, or intensely affectional attraction to men, to women, or to both men and women. It is also used to refer to an identity of a sense of self that is based on one's enduring patterns of attraction, and it is also sometimes used to describe an enduring pattern of behavior. Again, Herrick. Most social science and behavioral research has assessed sexual orientation in terms of attraction, behavior, or identity, or some combination thereof. Herrick. The vast majority of people are consistent in their behavior, their identity, and their attractions. Herrick. The Lohman study, the social organization of sexuality, sexual practices in the United States, Chicago, 1994, shows that 90% of people in Lohman's sample were consistently heterosexual in their behavior, identity, and attraction, and a core of 1 or 2% of the sample were consistently lesbian, gay, or bisexual in their behavior, identity, and attraction. Herrick. If I were a betting person, I would say that you do well to bet that a person's future sexual behavior will correspond to his or her current identity. Sexual orientation is commonly discussed as a characteristic of the individual. Sexual orientation is fundamental to a person's identity, and it is a distinguishing characteristic that defines gays and lesbians as a discrete group. Proponents' assertion that sexual orientation cannot be defined is contrary to the weight of evidence. Herrick. In his own research, Herrick has asked ordinary people if they're heterosexual, straight, gay, lesbian, or bisexual, and that is a question people generally are able to answer. Meyer. Sexual orientation is perceived as a core thing about who you are. People say, "This is who I am." It is a central identity that is important. Herrick. These sorts of relationships, the need for intimacy and attachment, is at the very core part of the human experience and a very fundamental need that people have. Herrick. If two women wish to marry each other, it is reasonable to assume that they are lesbians, and if two men want to marry each other, it is reasonable to assume that they are gay. Herrick. Researchers may define sexual orientation based on behavior, identity, or attraction based on the purpose of a study, so that an individual studying sexually transmitted infections may focus on behavior, while a researcher studying child development may focus on identity. Researchers studying racial and ethnic minorities similarly focus their definition of the population to be studied based on the purposes of the study. Most people are nevertheless consistent in their behavior, identity, and attraction. Herrick, responding to a cross-examination that sexual orientation is a socially constructed classification and not a valid concept, replied, "Social constructionists are talking about the construction of sexual orientation at the cultural level, in the same way that we have cultural constructions of race and ethnicity and social class. But to say that there is no such thing as class or race or ethnicity or sexual orientation is to, I think, minimize the importance of that construction." Badgett, in Best Practices for Asking Questions About Sexual Orientation on Surveys, states, includes a discussion about methods of conducting surveys. It does not conflict with the substantial evidence demonstrating that sexual orientation is a distinguishing characteristic that defines gay and lesbian individuals as a discrete group. Proponents campaign for Proposition 8 assumed voters understood the existence of homosexuals as individuals distinct from heterosexuals. Basis. Video supporting Proposition 8. Supporters of Proposition 8 identified homosexuals and those sympathetic to their demands as supporters of marriage for same-sex couples. Advertisement. Honest answers to questions many Californians are asking about Proposition 8 from Protect Marriage 2008. The 90% of Californians who are not gay should not have their religious freedoms and freedom of expression be compromised to afford special legal rights for the 2% of Californians who are gay. From Protect Marriage, Myths and Facts about Proposition 8. Proposition 8 does not interfere with gays living the lifestyle they choose. However, while gays can live as they want, they should not have the right to redefine marriage for the rest of society. Leaflet from the California Family Council, the California Marriage Protection Act, San Diego County's tipping point. The leaflet asserts that homosexuals do not want to marry. Instead, the goal of the homosexual community is to annihilate marriage. Frank Schubert and Jeff Flint, Passing Proposition 8 Politics. The Proposition 8 campaign was organized in light of the fact that many Californians are tolerant of gays. California Voter Information Guide, California General Election, Tuesday, November 4, 2008, states, while gays have the right to their private lives, they do not have the right to redefine marriage for everyone else. Individuals do not generally choose their sexual orientation. No credible evidence supports the finding that an individual may, through conscious decision, therapeutic intervention, or any other method, change his or her sexual orientation. Basis, Herrick. Herrick has conducted research in which he's found the vast majority of lesbians and gay men and most bisexuals as well, when asked how much choice they have about their sexual orientation, say they have no choice or very little choice about it. Herrick, at page 39, contains a table that reports data on approximately 2,200 people who responded to questions about how much choice they had about being lesbian, gay, or bisexual. Among gay men, 87% said they had experienced little or no choice about their sexual orientation. Among lesbians, 70% said they had no or little choice about their sexual orientation. Herrick demonstrates that 88% of gay men reported they had no choice at all about their sexual orientation, and 68% of lesbians said they had no choice at all, and another 15% reported a small amount of choice. Herrick, it is certainly the case that there have been many people who, most likely because of societal stigma, wanted very much to change their sexual orientation and were not able to do so. Herrick agrees with Peplow's statement that claims about the potential erotic plasticity of women do not mean that most women will actually exhibit change over time. At a young age, many women adopt patterns of heterosexuality that are stable across their lifetime. Some women adopt enduring patterns of same-sex attractions and relationships. Herrick, most people are brought up in society assuming they will be heterosexual. Little boys are taught they will grow up and marry a girl. Little girls are taught that they will grow up and marry a boy. And growing up with those expectations, it is not uncommon for people to engage in sexual behavior with someone of the other sex, possibly before they've developed their own real sense of who they are, of what their sexual orientation is, and I think that's one of the reasons why gay men and lesbians have experienced heterosexual intercourse. It is not part of their identity. It's not part of who they are, and is not indicative of their current attractions. Herrick, therapies designed to change an individual's sexual orientation have not been found to be effective, and that they've not been shown to consistently produce the desired outcome without causing harm to the individuals involved. Herrick is not aware of any major mental health organizations that have endorsed the use of such therapies. Perry is a lesbian and feels she was born with her sexual orientation. At 45 years, she does not think that it might somehow change. Steyer. Steyer is 47 years old and has fallen in love one time in her life with Perry. Zerillo. Zerillo has been gay as long as he can remember. Katami. Katami has been a natural-born gay as long as he can remember. Kendall. When I was a little girl, I knew I liked other boys, but I didn't realize that meant I was gay until I was probably 11 or 12 years old. I ended up looking up the word homosexual in the dictionary, and I remember reading the definition, and it suddenly dawned on me that's what I was. Kendall. I knew I was gay just like I knew I'm short and I'm half Hispanic. And I just never thought that those facts would change. California has no interest in asking gays and lesbians to change their sexual orientation or in reducing the number of gays and lesbians in California. Proponents admit that same-sex sexual orientation does not result in any impairment in judgment or general societal, social, and vocational capabilities. The Attorney General admits that sexual orientation bears no relation to a person's ability to perform in or contribute to society. The Attorney General admits that the laws of California recognize no relationship between a person's sexual orientation and his or her ability to raise children, to his or her capacity to enter into a relationship that is analogous to marriage, or to his or her ability to participate fully in all economic and social institutions, with the exception of civil marriage. Lamb. Gay and lesbian sexual orientations are normal variations and are considered to be aspects of well-adjusted behavior. Herrick. Homosexuality is not considered a mental disorder. The American Psychiatric Association, the American Psychological Association, and other professional mental health associations have all gone on record affirming that homosexuality is a normal expression of sexuality and that it is not in any way a form of pathology. Miller. Miller agrees that courts and legal scholars have concluded that sexual orientation is not related to an individual's ability to contribute to society or perform in the workplace. Same-sex couples are identical to opposite-sex couples in the characteristics relevant to the ability to form successful marital unions. Like opposite-sex couples, same-sex couples have happy, satisfying relationships and form deep emotional bonds and strong commitments to their partners. Standardized measures of relationship satisfaction, relationship adjustment, and love do not differ depending on whether a couple is same-sex or opposite-sex. Proponents admit that gay and lesbian individuals, including plaintiffs, have formed lasting, committed, and caring relationships with persons of the same sex, and that same-sex couples share their lives and participate in their communities together. Proponents admit that many gay men and lesbians have established loving and committed relationships. The Attorney General admits that gay men and lesbians have formed lasting, committed, and caring same-sex relationships, and that same-sex couples share their lives and participate in their communities together. The Attorney General admits that California law implicitly recognizes an individual's capacity to establish a loving and long-term committed relationship with another person that does not depend on the individual's sexual orientation. Pipla. Research that has compared the quality of same-sex and opposite-sex relationships and the process that affects those relationships consistently shows great similarities across couples both same-sex and heterosexual. Pipla. Reliable research shows that a substantial proportion of lesbians and gay men are in relationships, that many of those relationships are long-term. Young. Young agrees with the American Psychoanalytic Association statement that gay men and lesbians possess the same potential and desire for sustained, loving, and lasting relationships as heterosexuals. Young agrees that love and commitment are reasons both gay people and heterosexuals have for wanting to marry. Badgett, same-sex couples wish to marry for many of the same reasons that opposite-sex couples marry. Badgett, same-sex couples have more similarities than differences with opposite-sex couples, and any differences are marginal. Adam Romero, Census Snapshot, California, the Williams Institute, 2008. In many ways, the more than 107,000 same-sex couples living in California are similar to married couples. According to Census 2000, they live throughout the state, are racially and ethnically diverse, have partners who depend upon one another financially, and actively participate in California. Adam Romero, an article, Census Snapshot, California, published 2008, quote, in many ways, the more than 107,000 same-sex couples living in California are similar to married couples. According to Census 2000, they live throughout the state, are racially and ethnically diverse, have partners who depend upon one another financially, and actively participate in California's economy. Census data also show that 18% of same-sex couples in California are raising children. California law permits and encourages gays and lesbians to become parents through adoption, foster parenting, or assistive reproductive technology. Approximately 18% of same-sex couples in California are raising children. Proponents admit that gay and lesbian individuals raise children together. The Attorney General admits that the laws of California recognize no relationship between a person's sexual orientation and his or her ability to raise children. The Governor admits that California law does not prohibit individuals from raising children on the basis of sexual orientation. The Attorney General admits that California law protects the right of gay men and lesbians in same-sex relationships to be foster parents and to adopt children by forbidding discrimination on the basis of sexual orientation. The California Welfare and Institute Code 1603013A section states it is the policy of this state that all persons engaged in providing care and services to foster children shall not be subjected to discrimination or harassment on the basis of their clients or their own actual or perceived sexual orientation. The California Family Code, Section 297.5D, states the rights and obligations of registered domestic partners with respect to a child of either of them shall be the same as those of spouses. Case, Eliza B. versus Superior Court, 2005, the holding that under the Uniform Parentage Act, a person may have two parents of the same sex. Adam Romero, again, in an article entitled Census Snapshot, California, published 2008, states 18% of same-sex couples in California are raising children under the age of 18. Badgett, same-sex couples in California are raising 37,300 children under the age of 18. Same-sex couples receive the same tangible and intangible benefits from marriage that opposite-sex couples receive. Peplow, quote, my opinion, based on the great similarities that have been documented between same-sex couples and heterosexual couples, is that if same-sex couples were permitted to marry, that they also would enjoy the same benefits from marriage, unquote. Peplow, married same-sex couples in Massachusetts have reported various benefits from marriage, including greater commitment to the relationship, more acceptance from extended family, less worry over legal problems, greater access to health benefits, and benefits for their children. position statement of the American Psychiatric Association, an article entitled Support of Legal Recognition of Same-Sex Civil Marriages, published 2005, quote, in the interest of maintaining and promoting mental health, the American Psychiatric Association supports the legal recognition of same-sex civil marriage with all rights, benefits, and responsibilities conferred by civil marriage, and oppose restrictions to those same rights, benefits, and responsibilities, unquote. Marrying a person of the opposite sex is an unrealistic option for gay and lesbian individuals. Proponents admit that for many gay and lesbian individuals, marriage to an individual of the opposite sex is not a meaningful alternative. The Attorney General admits that for gay men and lesbians, opposite-sex marriage may not be a meaningful alternative to same-sex marriage to the extent that it would compel them to negate their sexual orientation and identity. Cirillo, quote, I have no attraction, desire to be with a member of the opposite sex, unquote. Herrick, while gay men and lesbians in California are permitted to marry, they are only permitted to marry a member of the opposite sex. For the vast majority of gay men and lesbians, that is not a realistic option. This is true because sexual orientation is about the relationship people form. It defines the universe of people with whom one is able to form the sort of intimate, committed relationship that would be the basis for marriage. Herrick, some gay men and lesbians have married members of the opposite sex, but many of those marriages dissolve, and some of them experience considerable problems simply because one of the partners is gay or lesbians. A gay or lesbian person marrying a person of the opposite sex is likely to create a great deal of conflict and tension in the relationship. Domestic partnerships lack the social meaning associated with marriage, and that marriage is widely regarded as the definitive expression of love and commitment in the United States. Proponents admit that there is a significant symbolic disparity between domestic partnership and marriage. Proponents admit that the word marriage has a unique meaning. Cott, describing the social meaning of marriage in our culture. Marriage has been the, quote, happy ending to the romance, unquote. Marriage, quote, is the principal happy ending in all of our romantic tales, unquote. The, quote, cultural polish on marriage is as a destination to be gained by any couple who love one another, unquote. Cott, question. Let me ask you this. How does the cultural value and the meaning, social meaning of marriage, in your view, compare with the social meaning of domestic partnerships and civil unions? Answer. I appreciate the fact that several states have extended, maybe it's many states now, have extended most of the material rights and benefits of marriage to people who have civil unions or partnership, but there really is no comparison in my historical view, because there is nothing that is like marriage except marriage, unquote. Peploe, quote, I have great confidence that some of the things that come from marriage, believing that you are part of the first class kind of relationship in this country, that you are in the status of relationships that this society most values, most esteems, considers the most legitimate and the most appropriate, undoubtedly has benefits that are not part of domestic partnerships, unquote. Badgett, some same-sex couples who might marry would not register as domestic partners because they see domestic partnership as a second-class status. Badgett, same-sex couples value the social recognition of marriage and believe that the alternative status conveys a message of inferiority. Tam, unquote. If, quote, domestic partner, unquote, is defined as it is now, then we can explain to our children that, yeah, there are some same-sex persons who want to have a lifetime together as committed partners, and that is called domestic partners, but it is not marriage. Domestic partners are not married under law. California domestic partnerships may not be recognized in other states and are not recognized by the federal government. California Family Code, sections 297 to 299.6, establishing domestic partnership as separate from marriage. The court asked the parties to identify which states recognize California domestic partnerships. No party could identify with certainty the states that recognize them. Plaintiffs and proponents agree that Connecticut, New Jersey, and Washington recognize California domestic partnerships. Quote, to the best of the administrative defendant's knowledge, Connecticut, Washington, D.C., Washington, Nevada, New Hampshire, and New Jersey recognize California domestic partnerships. Case of Gill versus Office of Personnel Management, decided July 8, 2010, holding that the Federal Defense of Marriage Act, DOMA, unconstitutional as applied to plaintiffs who are married under state law. Domestic partnerships are not available in Massachusetts, and thus the court did not address whether a person in a domestic partnership would have standing to challenge DOMA. See also in Re Karen Golinsky, decided 9th Circuit 2009, finding that Golinsky could obtain coverage for her wife under the Federal Employees Health Benefits Act without needing to consider whether the result would be the same for a federal employee's domestic partner. The availability of domestic partnership does not provide gays and lesbians with status equivalent to marriage because the cultural meaning of marriage and its associated benefits are intentionally withheld from same-sex couples in domestic partnerships. Peploe. There is a significant symbolic disparity between marriage and domestic partnerships. A domestic partnership is, quote, not something that is necessarily understood or recognized by other people in your environment, unquote. Peploe. As a result of the different social meanings of a marriage and a domestic partnership, there is a greater degree of an enforceable trust in a marriage than in a domestic partnership. Herrick. The difference between domestic partnerships and marriage is much more than simply a word. Quote, just the fact that we're here today suggests that this is more than a word. Clearly, there is a great deal of strong feeling and emotion about the difference between marriage and domestic partnerships. Meyer. Domestic partnerships reduce the value of same-sex relationships. The Attorney General admits that establishing a separate legal institution for state recognition and support of lesbian and gay families, even if well-intentioned, marginalizes and stigmatizes gay families. Perry. When you are married, quote, you are honored and respected by your family. Your children know what your relationship is, and when you leave your home and you go to work or you go out in the world, people know what your relationship means, unquote. Perry. Steyer and Perry completed documents to register as domestic partners and mail them into the state. Perry views domestic partnership as an agreement. It is not the same as marriage, which symbolizes, quote, maybe the most important decision you make as an adult you choose as your spouse, unquote. Steyer. To Steyer, domestic partnership feels like a legal agreement between two parties that spells out responsibilities and duties. nothing about domestic partnership indicates the love and commitment that are inherent in marriage. And for Starr and Perry, quote, it doesn't have anything to do with the nature of our relationship and the type of enduring relationship we want it to be. It's just a legal document, unquote. Starr, marriage is about making a public commitment to the world and to your spouse, to your family, parents, society, and community. It is the way to tell them and each other that this is a lifetime commitment. Quote, and I have to say, having been married for 12 years and been in a domestic partnership for 10 years, it is different. It is not the same. I don't want to have to explain myself, unquote. Zurillo, domestic partnership would relegate me to a level of second-class citizenship. It's giving me part of the pie, but not the whole thing. It doesn't give due respect to the relationship that we have had for almost 9 years. Katami, domestic partnerships, quote, make you into a second, third, and fourth-class citizen now that we actually recognize marriages from other states. None of our friends have ever said, hey, this is my domestic partner, unquote. Permitting same-sex couples to marry will not affect the number of opposite-sex couples who marry, divorce, cohabit, have children outside of marriage, or otherwise affect the stability of opposite-sex marriages. Peplow, data from Massachusetts on the, quote, annual rates for marriage and for divorce, unquote, for the, quote, 4 years prior to the same-sex marriage being legal and the 4 years after, show that the rates of marriage and divorce are no different after same-sex marriage was permitted than they were before, unquote. Peplow, Massachusetts data are, quote, very consistent with the argument that permitting same-sex couples to marry will not have an adverse effect on the institution of marriage. Peplow, allowing same-sex couples to marry will have, quote, no impact, unquote, on the stability of marriage. Bramlett and Mosher in the article First Marriage Dissolution, Divorce, and Remarriage, United States, published by the United States Department of Health and Human Services in 2001, states race, employment status, education, age of marriage, and other similar factors affect rates of marriage and divorce. Bramlett and Mosher in the article Cohabitation, Marriage, Divorce, and Remarriage in the United States, Vital and Health Statistics by the United States Department of Health and Human Services, published July 2002, states race and socioeconomic status, among other factors, are correlated with rates of marital stability. The American Anthropological Association, in a statement on marriage and the family, states the viability of civilization or social order does not depend upon marriage as an exclusively heterosexual institution. The children of same-sex couples benefit when their parents can marry. Badgett, same-sex couples and their children are denied all of the economic benefits of marriage that are available to married couples. The position statement of the American Psychiatric Association in the article Supportive Legal Recognition of Same-Sex Civil Marriage, published July 2005, quote, the children of unmarried gay and lesbian parents do not have the same protection that civil marriage affords the children of heterosexual couples. Tam, it is important to children of same-sex couples that their parents be able to marry. Peplow, a survey of the same-sex couples who married in Massachusetts shows that 95% of same-sex couples raising children reported that their children had benefited from the fact that their parents were able to marry.